4 submissions today. I will be addressing the first 2, and my co-counsel will be addressing the last 2. The first submission we put forth is that the trial judge did not err in applying the standard of care in the way that he did, and therefore Dr. Ward breached the standard of care and should be liable. The second submission we put forth is that in some instances of negligence cases, causation can be used as circumstantial evidence to inform the standard of care, and the present case is one of these applicable cases. The third submission follows that non-negligent causes should not be the burden of the plaintiff. The fourth submission we put forth is that deference should be given to trial judges in findings of fact, and respectfully, this is not what occurred in this case. To address the first issue at hand, we submit that the trial judge did not err in applying the standard of care, and therefore Dr. Ward breached the standard of care and should be liable. The standard of care for specialist surgeons such as Dr. Ward is assessed in regard to the conduct of other specialists in that field, who, as per Terneuzen and Korn, possess a reasonable level of knowledge, competence, and skill expected of professionals in Canada in that field. Taken from expert testimony in this case, it is agreed upon that the standard of care is to identify, protect, and avoid direct contact with or close proximity to the ureter when using an energy-emitting device like the ligature. According to expert testimony, close proximity is defined as 2 millimeters. To begin, the requisite standard of care is not meant to be a checklist that one tries their best to achieve, and respectfully, the majority erred in characterizing the standard in this way, without reference to if the surgeon was accurate in taking the steps. I quote from paragraph 4 of the appellant decision, Dr. Ward took the steps he described to identify and protect the ureter. These were essentially the same steps that Mrs. Armstrong's own expert surgeon conceded a reasonably prudent surgeon would use. Given this finding, the trial judge should have dismissed the action. Further, the majority did not highlight the need for accuracy when taking these steps in paragraph 28 of the appellant decision. If these steps were taken, including trying to stay a safe distance from the ureter, there would be no breach of standard. The key word that we would like to emphasize here is trying. Given that the standard is to take these necessary steps, the success in taking these steps is essential. Trying to stay a safe distance is not the same as actually staying a safe distance.
Counsel, I'm just going to interrupt there for a second. And wouldn't that essentially be putting on a standard of perfection if saying that they absolutely have to meet each one of those steps in the way that you've outlined?
Thank you. Though we understand and accept that the standard of perfection is definitely not a standard we'd like to impose, we'd like to reiterate that this is not what is happening here with Justice Mulligan. So he identified the steps provided to him by expert testimony that you needed to do essentially 3 things: identify, protect, and stay away from the close proximity to the ureter, meaning 2 millimeters. So we would like to say that we don't think it's enough to just try to take these steps. Essentially, we're speaking of the third step, the 2 millimeters. We would like to emphasize also the ideal circumstances that occurred in the case, given that there were no complicating factors present, and expert testimony highlighted that an injury of this kind should not occur if these steps were followed. We would like to just respond by stating, is asking a doctor, a medical professional, a specialist surgeon to follow these necessary steps accurately, given that there are no underlying or emergent situations or complicating matters, too much to ask? We believe it isn't, and we believe that this would not amount to a standard of perfection.
So, counsel, if I may, so the idea is that it's not perfection because it was such good conditions of this patient. So maybe they can't avoid the ureter in all circumstances, but here it is okay given the situation of the patient. Is that why you're drawing the distinction in order to make it not perfection?
Yes, that is where we are drawing the distinction and relying on the expert testimony of Dr. Bernstein to make this claim.
Thank you.
Okay. Thank you. So to continue, as cited by Justice Van Rensburg, there is a difference between using this appropriate technique and executing it properly. The trial judge inferred that Dr. Ward did not stay 2 millimeters away from the ureter through relying on his expert evidence. According to Dr. Hagen, had these steps been properly taken, there would not have been this type of injury, because during such a surgery, you should not be anywhere near the ureter. You should be centimeters away, and that it would not be possible to damage if these steps were followed. Relying on this evidence, the trial judge correctly found that Dr. Ward failed to take the necessary step of staying away from the ureter and thus breached the standard of care. Furthermore, the majority respectfully erred in characterizing Justice Mulligan as imposing a standard of perfection in his standard of care analysis, as we have already gone through. So expert testimony addressed the surgery occurred in these ideal circumstances. Dr. Bernstein's testimony addressed a zero risk of injury, but this does not impose a standard of perfection. We say that Dr. Bernstein's zero risk theory was stated in context with these ideal circumstances described. I quote from page 23 of the trial decision: "The rate of injury to the ureter in a case like Ms. Armstrong's, which had no abnormality or disease process increasing the risk of injury, should be zero. Without any other potential reasons to make the surgery more difficult, there should be a zero risk of injury to the ureter, as there should be no reason to be anywhere near the ureter. Given these facts, the argument is not to hold Dr. Ward to a standard of perfection, but just to hold him to the standard that was laid out by all experts. As there was nothing hindering him from following these steps accurately, Dr. Ward failed to meet the standard of care. Finally, there is no evidence provided that if a surgeon tried reasonably to take the steps, they could still ultimately come within 2 millimeters of the ureter. No experts identified that this was a possibility. In fact, and as mentioned, expert testimony highlighted the opposite, that staying away from the ureter was in complete control of the surgeon, especially in such ideal circumstances that were prevalent in this case. Therefore, based on the evidence before the trial judge, to stay more than 2 millimeters away from the ureter was a necessary step, not something that was far-fetched and not something that reflected a standard of perfection. Based on these findings, Justice Mulligan appropriately characterized the standard of care in using a ligature device near a ureter during a colectomy, and therefore was correct in finding that Dr. Ward had breached this standard. Moving forward to the second issue, we put forth that causation can be used as circumstantial evidence to inform the standard of care in this particular case. There is no disagreement between the trial judge and the Court of Appeal that the common law supports instances that require causation to be used before a standard of care analysis. In some cases, it is necessary to determine what happened in order to determine whether the standard of care was breached. In other words, on the facts, we will have to be examining and determining how the injury occurred. This is supported by case law. In Kennedy and Jackowitz, the court held at paragraph 6 that it is open to experts and to the courts to draw inferences of fact. It may be appropriate then for an expert or the court to infer from the nature of the injury what it was that the surgeon did. Firstly, it is important to address the discrepancy between the trial judge and the Court of Appeal in relation to this issue. The Court of Appeal did not disagree that causation can be used before a standard of care analysis in some cases. However, the Court of Appeal believed that this was only necessary in this case because of the trial judge's alleged misapplication of the standard of care. As already put forth, the standard of care was applied correctly by the trial judge, and now I will address that this case was a situation where causation could be used as circumstantial evidence to inform the standard of care. So to explain this, I would like to draw a distinction between causation being used as circumstantial evidence to inform the standard of care and the idea of the standard of care being informed by the outcome. The latter is not what is happening in this case. The difference between the two ideas is nuanced but important regardless. What we are arguing here in this case is that in trying to determine if the standard of care was met, causation can be looked at. Let me draw two differing questions here to further explain. For instance, when determining what the standard of care is, the question to ask is plainly, what is the standard of care? To find the answer, the common law will highlight what a doctor needed to do. This is not an instance that can be determined by causation, and this is not the instance that we are arguing should be determined by causation. This is to say that the standard of care would be informed by the outcome, and as mentioned, this is not what we argue. A separate question to ask, however, is, was the standard of care met? To find the answer, the court would look at if the doctor actually did the things that he was supposed to do. For this question, it can be necessary sometimes that factual causation is used to answer if the standard of care was met. We are looking at if the doctor actually did the things that he was supposed to do. This is the question that we are concerned with in the present case. Now that I have drawn the distinctions, I would like to turn to the facts of the case. Justice Mulligan had to rely on circumstantial evidence, including the nature of the injury, in order to determine how the injury occurred. This was done to then determine if Dr. Ward had breached the standard of care. There was nothing inappropriate done here, and in fact, this was required given the competing evidence explaining how the injury occurred. Justice Mulligan was offered two explanations on how the injury occurred. The first explanation was that Dr. Ward brought the ligature 2 millimeters.
I'm just going to interrupt you for a moment. I appreciate what you're saying about how sometimes causation can be helpful for the standard of care, but I'm a bit confused, and maybe you can help me with this, because when we're talking about negligence, I think it's fair to say that in most cases, the standard of care analysis is going to come before causation. In other words, you're not going to get to causation if there's not a breach of the standard of care. In my reading of this case, but please help me if I'm misunderstanding it, it's a pretty straightforward negligence case. You know, difficult evidence, competing expert opinions, absolutely. But what's so special about this case that you're suggesting that we can use causation and issues related to the cause of the injury to look backwards in terms of the standard of care? I worry that if we accept your position, the general application of negligence principles and standard of care coming first may fall to the wayside.
Thank you. And we definitely agree that in most, and if not standard negligence cases, it should be the standard of care as the first analysis. And we understand the worry there as well. However, the problem, I believe, in this case is that we are unable to find out if Dr. Ward breached these 3 steps, specifically this last step of staying 2 millimeters away, without finding out how the injury happened, what actually happened, and how the injury was caused. So I believe that Justice Mulligan, he laid out the 3 steps and he laid out the standard of care and then said, well, how do I come to the conclusion that this standard of care was breached if I don't first find out or take the expert evidence to infer what caused the injury and what steps were followed?
Doesn't that mean your argument fails then? If you can't tell me whether he came within 2 meters of the ureter, isn't that the end of the day?
Well, Justice Mulligan was able to infer from the expert testimony that he did come within 2 millimeters of the ureter. He was given the 2 competing evidence theories and he had to weigh each theory, and ultimately he did reject the defense's expert testimony and went with the plaintiff. Given this, and given that he was entitled to do such a thing and to infer what caused the unfortunate injury, we believe that that is enough to kind of go forward with the analysis and then go right back to the standard of care.
Thank you, counsel.
Thank you. So just to reiterate, causation bore directly on whether or not Dr. Ward had maintained an appropriate distance, and in turn, if he had breached the standard of care or not. Justice Mulligan would not have been able to determine whether there was a breach of standard of care without first using the circumstantial evidence of the thermal injury with the expert testimony to determine what actually happened. Therefore, in the circumstances of this particular case, using causation to determine whether the standard of care was breached was the correct approach. Thank you for your time. My co-counsel, pending any further questions, will deliver the appellant's final 2 submissions.
Good morning. My name is Caitlin Simone, and I'm representing Ms. Armstrong alongside my co-counsel, Kapetaneas. I express the same sentiment as her on the importance of this case and the implication it holds on our client, Ms. Armstrong. My first submission will address whether the plaintiff has the duty to rule out non-negligent causes. I will then proceed to my second submission on whether the majority erred in applying a correct standard of review, and if so, what the appropriate standard of review ought to have been applied. Thank you. At the Court of Appeal, Justice Pacheco, writing for the majority, stated that the trial judge should have dismissed the action because the plaintiff had not excluded non-negligent causes of action. Specifically, he stated that a plaintiff whose liability theory is that only negligence could have caused the injury in question is obliged to demonstrate that this is so, and that the trial judge is required to accept this before finding liability. Let me make this clear. Ruling out non-negligent causes is not the burden of the plaintiff. In negligence law, it is standard practice that the plaintiff has to prove a prima facie claim, and then the burden shifts to the defendant, who now has a duty to respond. There is no such responsibility for the plaintiff to rule out non-negligent causes. This duty of the plaintiff is out of scope. To expand this duty would be erroneous to what negligence law stands for, that being to ensure and protect the plaintiff from wrongdoings that bring liability in law.
Counsel, if I may, aren't you casting that net too wide? You know, you're telling me what Justice Petracco's exception was, and that was the fact that the plaintiff's theory rested on ruling out non-negligent causes. We're not talking about all negligence all the time. They're saying when your theory rests on it, the plaintiff has an obligation to do it. Now tell me, counsel, why is that unreasonable when we know the plaintiff bears the burden of proving their claim? If that's their theory, they got to make that theory out.
Yeah, and I was going to get into it a little later into my argument, but one of the main reasons it's a huge overstep of power from the plaintiff. They aren't in the position to rule out non-negligent causes. Specifically, they don't have the medical expertise. In this case, Ms. Armstrong was unconscious during the surgery. So to rule out non-negligent causes would just be an overstep in power.
But to add to that, counsel, isn't that why you engage experts in these cases, to put that evidence forward? Because I can see many cases where the plaintiff might not have put a case forward on a balance of probabilities, and to get it over that next hurdle, you have to then rule out non-negligent causes, which then makes your case more probable and likely to meet your burden. So I'm not quite sure why the plaintiff can't take on that burden as well.
To rule out non-negligent causes would create such a floodgate of arguments into our common law system, and I don't know if the courts can handle that imposition. It's always been the defendant who has to rule out these causes in case law. It's been time and time again. So I'm not sure how the shift would occur here. It has never been done before.
But is it really so much to have an expert be able to opine on how, you know, it's not asking the plaintiff to opine on it, as my colleague mentioned, it's having an expert opine on ruling out the causes, saying this would be the cause. There aren't any cause based on the facts of my experience that could cause this injury. Why is that so unfair to the plaintiff?
Well, we did see expert testimony come from both sides on, and specifically the anatomy of Mrs. Armstrong was normal. So arising from this, it could only seem that the only negligent cause of this injury, and it was reasonable for the trial judge to infer this, was from negligence. So I think there were expert witnesses coming forward and putting out their claims of what they thought the negligence resulted from.
So in essence, they got the evidence. You're saying the judge heard the evidence that there was only the negligent cause. So isn't that consistent with, so you're saying that the test is okay, that you have to prove negligent causes. It's just that you disagree with the Court of Appeal and saying that that wasn't made out here.
I guess in this case, the process in which this was done wasn't in the way in which the appeal level judge said it was. They both brought their arguments forward and then had to, and the judge had to infer what happened. So I would say yes, I do agree with what you just said. So getting back to my topic, I will bring your attention to the case law that supports this proposition that it is the defendant that bears the burden. So in Cooper v. Flood, the Alberta Court of Appeal ruled that when there's circumstantial evidence of negligence, the burden shifts to the defendant to produce counter evidence of non-negligent claims. This principle is in line with the reasoning that is seen by Justice Mulligan at trial. I would like to also note that in the dissent at Peel, Justice Van Rensburg states that the onus on a plaintiff in a medical malpractice case is not to disprove every possible theory that might be put forward by the defendant, let alone theories that are not raised at trial, but only on appeal. We have to think of it like this. If it were to be the case that the appellant was responsible for ruling out every non-negligent cause, this would lead to absurd consequences and would use the resources that our legal system cannot afford to waste. It would also require the plaintiff to make the defendant's defense. This would place a hardship on the plaintiff that is not appropriate given the pain they have suffered thus far in this taxing process. With that said, it would have been an error to require the trial judge to disregard Dr. Bornstein's testimony, the witness for the plaintiff, because he did not address fictitious non-negligent causes. It is a known fact that the nature of the adversarial system in our court holds the expectations that both parties will put their best foot forward. In this sense, parties and counsel decide what to include in their case and what to not include based on the strategy or goal they are looking to obtain. This allows for autonomy, which is what our legal system stands for. With that said, for a plaintiff to bear the responsibility of demonstrating possible non-negligent causes when none were raised by the defendant would require the plaintiff to hinder their own case. Additionally, in regard to speaking about medical malpractice, it is the defendant who is in the greater place to make claims regarding non-negligent causes. Expecting a patient to specify how a doctor was negligent may create a power imbalance, since they usually cannot know exactly what happened during the surgery. In this case,
my question there is, isn't everybody subject to everybody has the same discovery evidence? We go through discovery, we get the doctor's evidence, we get the plaintiff's evidence, we get everybody else's. And so everybody then at that stage is on a level playing field with the same information.
yes, I understand how that would be a problem, but here we are talking about at trial, there were two testimonies given, expert testimonies given about what had happened. And the trial judge inferred what account he would like. And from this, there were no non-negligent causes that came about this. So I think it was in the position of the trial judge to make this inference. And then putting it on the defendant is just an undue hardship that they shouldn't afford, especially this is the basis of negligent law. It has always been. And to change this would just fundamentally change what negligence law stands for.
Thank you, counsel.
Moving on, it is not the duty of the courts to decide what one party should have been included in their argument. It is a common principle that judges must decide cases only on the evidence presented to them at trial. Judges are not to speculate, rather they must make decisions solely based on the evidence. Respectfully, this applies to disagree with the majority's decision, which, as mentioned before, was that a trial judge who's prepared to proceed on the basis that only negligence could cause the relevant injury is obliged to consider and rule out non-negligent causes. The case law of Hansen v. Bari additionally helps to support this. In this case, it was ruled that a trial judge is not obliged to consider potential non-negligent causes when there is no evidentiary foundation to do so. The trier of facts is required to determine the standard of care and its breach based on the evidence and not on speculation. In application, it was thus not up to Justice Mulligan to rule out non-negligent causes, as there was no evidentiary basis before him to make these in regard to the injury of Ms. Armstrong. In Philip v. Ford Motor of Canada, the expectations of the adversarial system are laid out as follows. This procedure assumes that the litigants, assisted by their counsel, willfully and diligently present all the material facts which have evidentiary value in support of their respective positions, and that these disputed facts will receive from a trial judge a dispassionate and impartial consideration in order to arrive at the truth of the matters in controversy. A trial is not intended to be a scientific exploration with the presiding judge assuming the role of a research director. It is a forum established for the purpose of providing justice for the litigants. In the case at issue, there was no expert testimony accepted by the trial judge that provided a non-negligent reason for a surgeon to use the ligature within 2 millimeters of the ureter. I repeat, it is not the role of the judge to make speculation. With that said, the majority respectfully erred in its claim that the trial judge should have accepted.
I'm going to interrupt you just for a second, if you'll indulge me. I think that we'll both likely appreciate the Supreme Court of Canada's sentiments in Snell and Farrell, talking about using common sense and a kind of robust, pragmatic approach to causation. I'm wondering here, I appreciate what you're saying about non-negligent causes and some of the issues that can arise. And these are challenging questions. But if we take a step back and maybe take less of a granular approach, can't we just chalk this up to the fact that, look, it's a complicated procedure. There are issues that are going to arise. Just because something went poorly here doesn't mean that Dr. Ward made a mistake. And so I'm struggling a little bit here because maybe this is just something that unfortunately can happen, but it doesn't mean that it's negligence. And I appreciate what you're saying about the difficulty with non-negligence causes, but if we take a step back here, perhaps it's this court's role to make a common sense leap to say, this is very unfortunate and I feel for your client, but these things unfortunately happen.
Thank you, Justice. However, at the case at hand, Miss Armstrong, from the medical evidence, she had a normal anatomy. And in regard to her normal anatomy, the success of the surgery was very, very high. So the expert testimony shows that the only way in which a normal anatomy could have caused this damage would be if the ligature was brought too close to the ureter. And this could have only done, which was accepted by the trial judge, was through negligence. So I think that helps to answer the question there, that it wasn't just non-negligent causes that caused the damage to the ureter.
Thank you, counsel.
Moving on to our last issue, it is our finding that the majority failed to give deference to the trial judge's finding of fact. The purpose of a standard review is not meant to exist to overturn a trial decision owing that the court entertains a different interpretation of the facts before them. This is because a trial judge is in the greatest position to assess credibility, as they occupy a privileged position in assessing the demeanor and evidence of witnesses and what credibility and weight of law they should be given. The only time where it will become suitable for the appellate court to intervene on this matter is when the assessment of credibility is based on a misapprehension of evidence. At trial, this was not an issue. The judge makes findings of fact that were reasonable based on the evidence before him. With that said, respectfully, the conduct of the majority at appeal was an overstep. They did not respect the deference owed to the trial judge on his determination of fact and preference for one expert opinion over another. It is clear that the Court of Appeal overturned this decision because they took a different view of the evidence before them. This is very problematic and is outside their scope as adjudicators. At the Court of Appeal, the majority states if the trial judge expressed his findings on the standard of care in a less ambiguous fashion, they would have agreed with his decision. Respectfully, this is problematic. The Court of Appeal acknowledges that what the trial judge is attempting to say is correct, but the way in which he does communicate his message is incorrect. Due to the complexity of this case and the many factors involved, they are holding the trial judge to an unfair and mistaken level of perfection. This concludes our submissions. Thank you for your engagement and active listening.
The court now invites the counsel for the respondent to begin.
Thank you. Good morning, Justices. My name is Hiram Sutton, here on behalf of the respondent, Dr. Ward. My co-counsel is Charlotte McKenna. This appeal is about a surgeon who followed all the standard procedures of a surgery, but was still found negligent at the trial level based on an inappropriate standard of perfection. Dr. Ward performed a laparoscopic colectomy on the appellant, Miss Armstrong. We are here because the appellant experienced damage to her left ureter, despite the fact that Dr. Ward took the steps expected from a surgeon. Our friends believe that this result speaks to a breach of the standard of care. We submit that the standard of care when performing a colectomy is not a guarantee of success, and that Dr. Ward was not negligent. Before submitting my arguments, I would like to draw the court's attention to a few key facts that are central to our submissions. By the time of trial, Dr. Ward had performed at least 50 colectomies. He knew the standard procedures and he knew the dangers. Damage to the ureter is a documented risk of performing surgery with a ligature device. It was his practice to warn the patient of this risk. Laparoscopic surgery involves the use of a camera and magnification, which increases the difficulty of the surgery. Dr. Bernstein, one of the experts of the appellant, did not have personal experience in performing laparoscopic colectomies. And finally, no evidence was put forward that all of the documented injuries to ureters during colectomies amounted to negligence.
Counsel, I'm just going to go back to your third point there, just since that's a basis of the rest of your submissions. Aren't we obliged to follow the trial judge's acceptance of Dr. Bernstein's qualifications? You're saying now that he doesn't have qualifications in doing this kind of procedure, but isn't that far gone now that you're at the appellate level?
It is. Yes, Justice, it is the trial level's prerogative to review the evidence in front of him. But in this case, the standard of care was a question of law. So the Court of Appeal does have the right to overturn that. But this appeal is about whether this colectomy amounted to negligence. And there are several issues on appeal. I'll be speaking to the first two issues, which fall into the category of the standard of care. They are, what is the requisite standard of care for medical negligence in Canada as correctly applied to this case? And can or ought ever causation be used as circumstantial evidence to inform standard of care? I will argue that the standard of care is performing to the standard of a reasonable surgeon, and that causation can be used as evidence, but not in this case. A third issue is raised under the standard of care. Does the plaintiff have a duty to rule out non-negligent causes? My co-counsel will speak to this issue, as well as the standard of review question. Did the majority err in applying a correctness standard of review? She will demonstrate that the plaintiff does have a duty to rule out non-negligent causes, and that the majority did not err in applying a correctness standard of review. I will be making three arguments. First, the standard of care involves identifying and trying to stay away from the ureter. Second, a finding of negligence in this case would amount to a standard of perfection. And third, causation may be used as circumstantial evidence in some cases, but not in this case. My friends agree that the standard of care for professional negligence is performing with the reasonable care expected from a professional with similar training and experience. Experts were brought into trial to determine this reasonable care, and the trial judge made a finding based on that evidence. The Court of Appeal decision refers to this finding at paragraph 49. Quoting from that paragraph, the standard procedure for removing a benign colon during a colectomy is identifying the ureter through vermiculation, moving it away from the colon before proceeding, and rechecking the location of the ureter by periodically repeating the vermiculation, trying to avoid bringing the ligature within an unsafe proximity to collateral tissue. This procedure is the standard of care. My friends submit that the standard of care shouldn't include a term like trying, but frankly, that's not for us as non-medical professionals to decide. The experts testified that this was the standard procedure, and the trial judge accepted that testimony. There were no steps put forward that Dr. Ward did not take. In this case, all the experts agreed about the surgical steps. One expert, Dr. Bernstein, the appellant's expert I referred to previously, held the opinion that the ureter should never be damaged during a normal colectomy, and that if a surgeon performed all the steps I described, the risk of injury should be zero. But recall that the standard of care is performing with the care expected from a professional with similar training and experience. Without having performed a laparoscopic colectomy, he does not have similar training or experience to Dr. Ward for this specific surgery. As I said, the standard of care in a given situation is a question of law, as my co-counsel will go into more detail about later. Respectfully, the trial judge erred in finding that the standard of care is breached by touching the ureter or coming within 1 or 2 millimeters of it with a ligature device. This finding put too much weight on the result rather than the steps taken to achieve that result. I will return to this point in just a minute. But in this case, the reasonable steps were submitted by experts and accepted by the trial judge, and those steps should have been accepted as the standard of care. Having identified that the standard of care involves identifying and trying to stay away from the ureter, the question then becomes whether Dr. Ward breached that standard of care. This involves the application of fact to law. Questions of mixed fact and law are reviewable only for overriding and palpable error. In this case, the trial judge, considering all the evidence before him, determined that Dr. Ward did in fact take all those steps. Such a finding should have led to a determination that Dr. Ward was not negligent. Yet his liability,
With respect here, it seems like you're cherry picking a little bit what you want to call a fact and what you want to call the law. So if you want to call those things facts and that those are on a palpable and overriding standard, the same would go for Dr. Bernstein's qualifications, which are more factual here and not an issue of law. So how do you want us to take this? Is it all palpable and overriding for those issues, or is it something that we can get into with a little less deference?
Respectfully, Justice, the question of what the standard of care is a question of law. To your point, Dr. Bernstein's qualifications is a finding of fact that that the trial judge had the right to weigh in determining that standard of care. But ultimately, what the standard of care is merely a question of law. Now, whether Dr. Ward breached the standard of care based on the evidence and based on the facts that the trial judge had, those are findings of fact, and those are things that cannot be overturned by the Court of Appeal. So to summarize, the standard of care is a question of law, but whether or not Dr. Ward in fact breached that standard of care would be mixed law in fact. Again, the finding that Dr. Ward did not succeed in keeping a safe distance from the ureter, and that that is what resulted in negligence in this case, put inappropriate weight on the result rather than the means taken to achieve the result, which created a standard of perfection.
Counsel,
which brings me, yes.
Sorry, before you move on from that point, doesn't this rule, the appeal court's ruling, suggest that medical professionals have the defense available? Well, I didn't do it right, but I tried to do it right, and that's going to be sufficient. And if that's what was being set by the Court of Appeal, tell me first if you agree that that's what it is, because that's how I read it. But then second to that, if that is the case, how then does a plaintiff, undermine the idea from a medical professional, hey, I tried to do it right? Because every medical professional can say that. I intended to do things right. How does a plaintiff counteract that?
Yes, Justice. To answer your question, first, it's important to recognize that that particular step in trying to stay away from the ureter is only applicable to this case. That was the reasonable step that was suggested by the experts for performing this surgery. So it's not going to create any...
Doesn't the analysis about steps, and you're trying to draw a distinction between outcome and steps, doesn't that open the thinking here by the Court of Appeal to apply more broadly?
Again, this analysis, this standard of care only applies to this surgery, so it wouldn't open broadly. But to your point, Justice, that trying to stay away from the ureter could be put too much emphasis on simply what the medical professional subjectively tried to do, and it could be based on their testimony. To that, I respond that that's when the trial judge has to look to the other steps that were taken throughout to determine whether he actually tried and sufficiently took steps to stay away from, in this case, staying away from the ureter. So it's not just based on subjective testimony that, yes, I tried. Of course, that would open the floodgates and make it impossible for a plaintiff to rebut. But the trial judge has the duty to examine all the evidence, make sure that the vermiculation was being repeated, that he did remove the ureter away from the colon, and continue doing that throughout the procedure.
Thank you, counsel.
A standard of perfection, like I was referring to before, creates an absolute duty. This is the highest standard that can be applied in law. It means that the goal must be attained regardless of circumstances. Any failure to achieve the desired result invites liability every single time. In a perfect world, this may be desirable, but it does not take into account the fact that professionals are human and they make mistakes. Professional negligence accounts for this human aspect and only asks professionals to perform to the standard of a reasonable professional with similar training and experience. At paragraph 21 of our factum, we point to two Supreme Court cases that demonstrate that courts should look to the means to achieve a result rather than the result itself. In this case, the result was performing the colectomy without damaging the appellant's ureter. The means to achieve this result were the steps already described: identifying the ureter, moving it away from the colon, rechecking its location, and trying to avoid bringing the ligature within an unsafe proximity. The trial judge accepted that these were the steps a reasonable surgeon would take. He also accepted that Dr. Ward did, in fact, take these steps. Unfortunately, the appellant still suffered an injury. The result is tragic and undesirable, but that doesn't justify looking merely to the result in order to determine the standard of care. If Dr. Ward took all the steps to protect the appellant's ureter, but is still found negligent simply because an injury occurred despite those steps, a standard of perfection would be created. And the only time a standard of perfection could be appropriate is if all non-negligent causes have been ruled out. My co-counsel will explore that particular issue further, but suffice it to say for now that this did not happen in this case. Thus ruling out a standard of perfection, the question remains whether Dr. Ward took the steps of a reasonable surgeon with similar experience. The trial judge found that he did, and barring a palpable and overriding error, there is no reason to overturn that finding. Having met the standard of care, Dr. Ward cannot be found negligent in this case. The second issue on appeal is whether causation can be used as circumstantial evidence to inform the standard of care. We submit that causation may only be used as circumstantial evidence when the standard of care cannot otherwise be established. This is not such a circumstance. At paragraph 29 of our factum, we review some of the case law where causation was used to determine the standard of care. This case may seem similar to those cases, but there's an important difference. The standard of care in this case was already described by the experts and does not change depending on the cause of the injury. At paragraph 56 of Marangolo and Oshawa General Hospital, Justice Osborne referred to the traditional negligence causation question. Can it be established that the defendant's breach of duty caused a plaintiff's injury? Note that the breach of duty is already established in that causation question. That case had to deviate from the traditional ordering of the questions because it was a unique situation. And to your point from earlier, Justice Carroll, in a usual negligence analysis, the issue of causation comes after a determination that the defendant breached the standard of care. In other words, if a defendant has breached a standard of care, the court then considers whether he or she caused the injury or damage.
Right, but
So
counsel, here, we're not determining but for causation at this stage. We're looking at what the injury was and looking at whether that gives us any circumstantial evidence of what actually happened in that surgery. And in this case, how do we know if he actually protected the ureter and didn't come too close to it unless we know what the injury was? In this case, a thermal one that showed that he came too close to the ureter. So I'm failing to see how we can actually separate those things in this case.
Yes, Justice. All we're saying is that the standard of care was already established by the expert's testimony, and that standard of care, the reasonable steps that the surgeon must have taken, does not change depending on the cause of the injury. So whether or not he caused the injury, the reasonable steps he should have taken were still to identify the ureter, move it away through the vermiculation, and try to remain away. I do see that my time has elapsed. May I finish answering your question and conclude?
Yeah, I think we're allowed to give you an extra couple of minutes. And I just want you to address there is I don't think we're talking about the cause of the injury influencing what the standard of care is, but whether it was actually met. And so I think that's an important distinction that I'd like you to address in your closing.
Thank you. Yes, the standard of care, as you said, was already established, and the question is whether or not he breached it. But we submit that regardless of whether he in fact caused the injury doesn't change whether he breached the standard of care, because if you recall, our submission is that the standard of care is simply the reasonable steps taken to avoid damaging the issue. We do submit that the trial judge erred in finding that coming within 2 millimeters of the ureter, in fact, was a breach of the standard of care. Therefore, even if he did come within 2 millimeters of the ureter to cause the injury, it doesn't change whether he breached the standard of care. And the but-for analysis of whether he did, in fact, cause the injury, which of course was an issue at trial and was found against the respondent, against the defendant, Dr. Ward, doesn't affect whether he actually breached that standard of care. He took the reasonable steps expected from a surgeon in those circumstances, and therefore he met his standard of care.
Thank you, counsel.
Just to conclude briefly, our friends submit in their factum that the goal of the surgery was not to not injure the ureter, and we agree with this. We submit that the true goal of the surgery was simply to remove the colon, and that steps must be taken to ensure that other organs are not injured. Dr. Ward did, in fact, take those steps and should not be found negligent for doing so. Subject to any further questions, these are my submissions. I will now turn the time over to my co-counsel, Ms. McKenna, who will speak to non-negligent causes and the correctness standard of review.
Good morning. My name is Charlotte McKenna, here on behalf of the respondent, Dr. Ward. As my co-counsel has put forward, we have been arguing that the standard of care had been determined by the experts as trying to stay away from the ureter, that the respondent should not be held to a standard of perfection, and that causation may be used as circumstantial evidence in some cases, but not at the case at hand. I will be speaking to the next two submissions regarding the plaintiff's duty to rule out non-negligent causes and the correctness standard of review having been properly applied. First, I will be speaking to the fact that since the standard of perfection was applied, the plaintiff had a duty to rule out non-negligent causes for the injury. Non-negligent causes were not ruled out by the appellant or considered by the trial judge. A standard of perfection being applied is only appropriate when it is clear there are no other ways in which the injury could have occurred. I will then consider the standard of review that was applied. Since the standard of care was applied incorrectly and is a matter of law, the correctness standard of review was appropriate standard to apply in this case. This leads me to my first submission, which is that the appellant, the plaintiff in this case, had a duty to rule out non-negligent causes. Without looking to other potential causes of the injury, a standard of perfection was created. When one is elevating the claim of negligence to a standard of perfection, the plaintiff is required to rule out non-negligent causes. As my co-counsel indicated, the standard of perfection was not the appropriate method of determining negligence in this case.
Counsel, isn't that your obligation as Dr. Ward's counsel to, like, for example, the earthquake example? Why is it plaintiff's counsel's role to come in and say, well, there wasn't an earthquake and this is why there wasn't? If there was an earthquake, shouldn't Dr. Ward be saying, hey, look, this happened because there was an earthquake. There was no control over this, and he put that forward, and then plaintiff's counsel have to respond to that. I'm really struggling with why plaintiff's counsel has to come up with all of these potential non-negligent causes and rule them out if there's no evidentiary basis for them.
So in this case, the standard of care was improperly applied. Improperly applied in the fact that the negligence was determined on the goal of the surgery and not the steps taken to perform that surgery. So when that happens, a standard of perfection is created. The defendant's role is only to respond to what the plaintiff has put forward and rebut those accusations or complaints in this case.
But a part of doing that sometimes, like a plaintiff may meet their burden initially with a prima facie case, and then it's your responsibility as the defendant to try and rebut that. And sometimes that means bringing other evidence that isn't just directly responding to what the plaintiff said. So, I mean, if Dr. Ward knew, for example, that an earthquake happened and that's why he got too close to the ureter, isn't it his obligation to bring that evidence forward?
I do see what you're saying. However, in this case, the goal of the surgery was focused, the standard of perfection was held in the fact that it was the goal of the surgery that was being looked at to determine negligence and not the steps taken in this case. You are correct in saying that the defendant does have to rebut the presumptions. However, in this case, since standard of perfection was applied, there needs to be some sort of, I guess one must look at other potential causes. For example, which I will bring up later in my submissions, is that having the ureter outside of the view of a microscope was not considered whether that was negligent. And this is something that maybe could have been looked at by the trial judge in determining whether there was negligence in this case, and instead of imposing a standard of perfection. To continue, the standard of perfection can be used in certain cases, but only where non-negligent causes have been ruled out. Situations where non-negligent causes have been ruled out are issues such as leaving surgical tools inside a patient and removing the wrong limb. These scenarios are only possible if the surgeon has been negligent. In these instances, there are no other reasons for the injury besides the surgeon's negligent conduct. Had the surgeons in these scenarios taken the steps a reasonable surgeon would, those mistakes simply would not happen. In this case, however, we know that the respondent took the steps that a reasonable surgeon would when performing a colectomy, as noted by the trial judge at paragraph 28. Yet, as we know, the injury still occurred. The trial judge established that the respondent was liable regardless of having taken the appropriate steps. Without such consideration as to whether there was a potential non-negligent cause of the injury, as I'd indicated earlier, there is no demonstration that the respondent breached his standard of care owed to the appellant. It is not the defendant's duty to rule out these non-negligent causes, as indicated at paragraph 34 of our factum. A plaintiff has a duty to rule out non-negligent causes, given they are the ones accusing the defendant of the negligent act. In fact, as noted by the majority of a court of appeal, the defendant only has the responsibility to provide a defense for the causes of action put forward by the plaintiff, as I had previously noted. The respondent must only prove that the conduct did not amount to negligence in the circumstances described.
Counsel, if we accept that the standard of care has been breached here, right? We're talking about causation. Let's say standard of care is breached, liability, we're moved on to that causal analysis. What kind of non-negligent cause here could be relied on by anyone, whether it's you or counsel for Ms. Ward, to try and say that liability can't be established because it fails on causation? What kind of non-negligence cause would be sufficient to break that causal link?
In this case, one could potentially look to in the causation to say that, but for the, respondent's actions, the injury would not have occurred. One could look potentially towards, for example, an accident, for example, or if they did breach the standard of care, you could potentially look at other factors that could have contributed to it, such as, I think it's indicated in the Ontario Court of Appeal. It was noted that potential heat creating tissue could potentially, creating scar tissue could potentially create the damage that was inflicted, but wasn't considered. This was something that was put forward by Dr. Hagan. But in this case, that is potential rationale for him not having breached causation in this case.
I guess what I'm getting at is that even if we accept that maybe there are some pie in the sky non-negligent causes here, certainly the defendant's conduct would be a cause, if not the cause, to Ms. Ward's injuries. Would you agree?
Yes, in this case, what we're looking at is in a lot of in most surgeries, there is a risk that that patients do take when surgeries are performed. And in this case, damage to the ureter is an unfortunate accident that happened, or unfortunate incident that happened. However, our arguments are that the standard of care was not breached in this case because the doctor took the appropriate steps taken. So one must not then look to causation because he did not breach the steps taken that a reasonable and prudent physician did. And as was noted by my co-counsel, this is a documented injury. Although it is a low percentage of a documented injury, it is still documented. So these situations do happen even when the standard of care has been met and the steps taken have been met. Does that satisfy your question, Justice Carroll?
Thank you.
Thank you. To echo my co-counsel, given that both the trial judge and the Ontario Court of Appeal identified this as a factual causation, one must determine that if the standard of care was indeed breached, then the next step in determining negligence is considering that the cause of that breach was done, but only done for the person's negligence. Subsequently, then it was open to the trial judge to consider non-negligent or accidental causes, given the facts presented to them. In particular, Dr. Bernstein's evidence did not address why accidental but non-negligent causes could be ruled out. The facts were put before the trial judge to make such a consideration. However, no consideration was given. In addition to the standard of perfection being applied, it was also not considered if an injury occurring outside the view of the microscope, as I indicated previously in my submissions, would be considered a negligent injury. As I have also previously noted, there is documentation of this kind of injury occurring. As no finding was made that the only way to obtain such injury was through negligence, the standard of perfection was not the correct standard to apply. If the respondent is to be found negligent, it must be based on the steps he took to ensure that the appellant's safety during the procedure. The steps taken during the surgery, as iterated by my co-counsel, were accepted by the trial judge. The respondent indeed took these steps that a reasonable surgeon would. Therefore, the test should have ended at the standard of care stage, and the respondent should not be found negligent in this case. This leads me to my second submission. My second submission is that the correctness standard of review was properly applied by the majority court of appeal.
So just before we move on to that, am I correct to say that you agree if this court finds there was a breach of the standard of care, however we may frame that, then liability is established because causation is clear?
In this case, it would be necessary to look at, given that this was a standard of perfection that was created, I think it would be important to look at other potential issues. Such, for example, as I had previously noted, it was open to the trial judge to consider other areas of how this could have occurred, such as the microscope, the ureter being outside of the microscope, or potential non-negligent causes. As no non-negligent causes were brought up by the plaintiff's side and could have been considered as options, it is our submission that there is not enough evidence to establish causation without looking to a standard of perfection in this case.
Thank you.
Thank you. So to my second submission was that the correctness standard of review was properly applied by the majority court of appeal. It is well known that deference must be given to the trial judge when it comes to appeals. However, when the law is incorrectly applied, the Court of Appeal is able to replace the opinion of the trial judge with their own. This rule is necessary to ensure that the law is applied appropriately in similar situations that may arise and does not cause confusion on the correct application of the law. In addition, the Court of Appeal requires a broad scope of review when it comes to matters of law. The issue before us is the correct application of the standard of care. As the Court of Appeal noted, it is an error of law to use outcomes or goals as a standard of care. As my co-counsel has indicated, the standard of care was improperly applied in this case. Given that it was improperly applied, this corrected standard of review was appropriate. This gave the Court of Appeal the authority to replace the incorrect application with that of its own. The standard of care required for the surgery should not have been the goal of the surgery, but the steps taken to meet that goal. The steps were indicated by the trial judge as having been followed. Nevertheless, Dr. Ward, the respondent, was found negligent. In addition, as noted by my co-counsel, the mistaken order of analysis regarding the standard of care and causation contributed to this incorrect ruling. The Court of Appeal indicated that the standard of care was to come first before causation. Since this case was one where causation was not needed to be looked at first before standard of care, as a standard of care had been identified, the application of the law by the trial judge was incorrect. As has been noted in our factum at paragraph 39, the correct inquiry to be made in assessing whether a professional committed a fault is indeed to ask whether the defendant behaved as would a reasonably prudent and diligent fellow professional in the same circumstances. We know that the standard of care was to follow a series of steps that I have previously noted in performing a colectomy while protecting the ureter, which the respondent took. The trial judge used the incorrect application to determine the negligence had occurred, creating a standard akin to a guarantee, which has never been the law. This was similarly the case in Carlson and Sutherland. In this case, the trial judge found that the patient established a prima facie case of negligence based on the fact that blood vessels were inadvertently cut during surgery. However, the British Columbia Court of Appeal ruled that the standard of care imposed on the physician amounted to a standard of perfection, which is not law, therefore allowing the Court of Appeal to replace the ruling with their own. The trial judge also did not identify any steps the respondent had failed to take. This indicates that the standard of care was indeed met, but again, improperly applied, focusing on the goal and not the steps of the surgery, again affirming that the correctness standard of review was properly applied by the Court of Appeal. To conclude, the standard of care in this case was met by the respondent, Dr. Ward. Through the incorrect application of the law, the trial judge unfortunately deemed him negligent. We submit that the true goal of the surgery was to remove the colon and that steps must be taken to ensure that other organs are not injured. Dr. Ward took those steps. No non-negligent causes were ruled out and no experts, I see my time is up.
You can finish up your conclusion, counsel.
Thank you. No non-negligent causes were ruled out, and no experts stated whether the ureter being out of the view of the microscope during the surgery was in fact negligent, indicating that the standard of care had been met. The standard of review was correctly applied in this case, given the trial judge erred in his application of the standard of care. We respectfully ask that the appeal be dismissed with costs. Subject to any further questions, these are my submissions. Thank you.
Thank you, counsel. The court now invites counsel for the appellant to begin their optional 3-minute rebuttal.
Thank you. Firstly, we would like to bring up that it is a mischaracterization to state that the trial judge has outlined the standard of care to be a goal of a surgery and not the steps taken. As we believe that the standard of care was laid out appropriately, that meaning including this third step that we've emphasized of staying 2 millimeters away, Justice Mulligan focused on matching how this injury was caused with the steps taken. Again, we would like to reiterate there that Justice Mulligan's analysis did in fact focus on the precise manner in which the surgeon failed to meet the standard of care. He did not focus on the result. The fact of the matter is, Karen Armstrong lost a kidney, and it is up to the trier of fact and the parties involved to conclude how and why that happened. Respectfully, we disagree that Justice Mulligan only looked to the results. He used the circumstantial evidence to infer what happened, something that he is entirely entitled to do. As discussed, this is not but for causation. This is understanding what injury occurred and how such an injury could occur. How do we know if he did not come too close to the ureter without knowing what the injury was? The injury was a thermal injury, and it was testified that this would have happened if the ligature came too close. When there is no definite conclusion on how such an injury occurred, it is up to the courts to rely on the expert evidence to provide their theories, and then it is up to the trier of fact to weigh that evidence and infer what happened. It would be unfair and unjust to a plaintiff for a defendant to not to be held liable because we will not allow a trial judge to infer what caused the injury. To state that because there was only circumstantial evidence and to say that it is not enough and the surgeon apparently took the steps without knowing if he actually took the steps would lead to injustice for plaintiffs in many medical malpractice cases. We don't know that he actually took the steps without looking at inferring what happened. Again, something Justice Mulligan was entirely entitled to do. Therefore, Justice Mulligan was correct to infer the causation based on the evidence before him and was correct to then conclude that the standard of care was breached. If the steps of the standard of care are laid out as followed, as we've submitted: 1, identify the ureter; 2, protect the ureter; and 3, stay away from close proximity to it, meaning 2 millimeters. Then through expert evidence and the thermal injury as circumstantial evidence, the trial judge was able to infer that the injury was caused from being 2 millimeters close to the ureter, therefore breaching that third step. He thus clearly failed to take that necessary step that we have so emphasized, staying away from the ureter. We, the appellants, cannot see how the standard of care cannot be breached based on these findings of fact that the trial judge should be given deference to and was entirely entitled to make. Thank you.
This concludes the matter of Armstrong against Ward. Thank you all very much. Judges, I would like to remind you to send your score sheets to the email that I will be putting in the chat. I will keep the session running. The next one starts at 11:30. You're all welcome to stay until then.
Thank you, counsel. You all did a great job.
Great job.
Thank you. Thank you for participating in the moot.
Thank you.
Take care, everyone.